Greetings. Wanted to go over a letterogatory with you I used a long time ago in a court case. State of Nebraska versus Derek S. Gonzalez, letterogatory for relief under the Hague Convention, Title 18, subsection 1781. I, Derek Gonzalez, beneficiary for the Derek Gonzalez Sestakay Trust, to notice the court of my letterogatory to the Kearney County Court and demand my name be cleared of this alleged criminal case for the reasons set forth below. I, Derek Gonzalez, have learned that this alleged court that has scheduled a case cause claim against me is not really a court as per the Constitution of the United States of America, but rather a tribunal operated as a private corporation. I have learned of the fraud that goes on behind the scenes of these alleged criminal cases, which are really civil claims in equity, and the steps taken to securitize these civil claims without giving full disclosure to the people. I am hereby letting the court know that I am opting out of any contract and do not allow any documents regarding me or my Sestakay Trust to be securitized and sold to any investors, etc. The fraudulent process is as follows. All cases are civil, though often fraudulently claimed criminal. The courts are operating under trust law, assuming the defendant is a decedent. After finding the alleged defendant guilty, the court clerk sells the judgment to the federal courts. Since the defendant is a decedent, the court officials consider themselves as a beneficiary. When a judge asks if a person understands, she is asking if the person is liable for the bond. I am not responsible for the bond of this case, but I will appoint the judge as trustee fiduciary and be the beneficiary of all proceeds. The judgments are stamped with something to the effect of paid to the order of on the back and taken to the federal discount window. The judgment now becomes a note. The notes are then pooled together and then become securities, which are yet pooled together and sold as bonds. Said bonds are liens against me. The United States Attorney's Office has a put code number, an NAICS, North American Identification Security Classification. Said NAICS number enables the United States Attorney's Office to trade globally all securities. All U.S. federal courts are registered with the DoD, the Department of Defense, where they are registered with the CCR, Contractor Central Registration, under the DoD, which another department called the DLIS, Defense Logistics Information Service, which issues a cage code, which means a commercial and government entity, which everything corresponds with their bank account. Said United States Attorney's Office and courts have a DUNS number, Duns and Bradstreet, 11. Everything filed into a court is securitized without the knowledge or the consent of the people or of all the parties. 12. All criminal cases not heard in an Article 3 court, District Court of the United States, are really civil. However, the courts again commit fraud by labeling the cases as criminal. All cases which are pled out or have a guilty conviction label the civil defendant through unlawful conversion as a felon, when they are not. This is a fraud upon the people at large, and certainly fraud upon the alleged defendants. The bank account is a Federal Reserve Bank of New York in New York City. The depository agreement is signed by the clerk of the court. All securities are then deposited with the DTC in New York. An escrow agent is used as a go-between between the clerk's office and the Federal Reserve Bank of New York. The securities end up being listed through the 7th Circuit, Chicago, Illinois, then sent to the DTCC, the clearinghouse, whom lists the securities for trading. All of the lawyers involved are acting as private debt collectors according to the FDCPA, Title 15, subsection 1692. The Bar Association exempts them from having to be registered as such. However, they operate through call warrants, which are like a put or a call. Doing margin calls is where they convert a case through, similar to a writ of execution, and use the case number to buy equity securities. Everything filed into the court is securitized and turned into a negotiable instrument, and then turning them into securities. These items are sold are sold commercial items, calling them distressed debts. Unifund. The items are then pulled together in what is now called a hedge fund, where they are sold globally. Anytime when there is risk management involved, it is for the securities. This is an underwriting company. When the hedge funds are going into the global market, they go through Euler Hermes, EULERHERMES, a bondholder and an underwriting company and subdivision of Allianz SE, ALLIANZ SE, of Munich, Germany, PIMCO bonds. After 9 months, all paper is converted to security status. This is defined in Title 15, subsection 77, AB1, and now considered to be an investment contract. The paper is endorsed to become a security, and the trust is then collapsed. The courts have an account with the IMF, International Monetary Fund, under Interpol. The judges involved and the U.S. attorneys involved do not have an accessible oath of office because they cover up the fact that the oath of office is between them and the IMF. The U.S. judges and U.S. attorneys are actually employees of the IMF and have expatriated out of the United States. They are now unregistered foreign agents under Title 22, which states all foreign agents must be registered. The court's judgments are deposited with the IMF. Since this case obviously involves me, I have a drawing right to all the proceeds. See UCC subsection 3-305 and subsection 3-306. The court's judgments are monopolized according to Title 16, which is a violation of the antitrust laws and also unfair trade practices. 24. Indictments are true bills, meaning they are negotiable instruments. The district attorney failed to give me a 1099 OID showing me as the recipient of the funds, which is a fraud upon me. In my case, I have not been indicted but still request a 1099 OID unless the court wishes to close this account. The unlawful funds, through fraud and deception, and deposited into the Federal Reserve Bank of New York, and they have not paid the taxes on this income. According to the IRC, this is a subsection 7201 of Title 26 violation, willful failure to file with the intent to evade the taxes. A copy of the depository resolution agreement was not made available to me from the clerk of the court. The clerk of the court makes deposits into the Federal Reserve Bank of New York via electronic fund transfer, EFTs. The clerk of the court has a PMIA, private money investment account, which also has a government code. According to the clerk's practice, the clerk of the district court is the registrar in admiralty. According to the IRS, subsection 6209 decoding manual and the ADP automated data processing manual, all 1099s are class 5 gift and estate taxes. I'm asking for the 1099 OID in this case, as I am not willing to gift you the proceeds. I am hereby asking for the proceeds in their entirety, including interest. I have never pledged my rights or my body to any gifting program, including any of the court's processes. I am not a charitable organization. I demand all funds from this case be sent to me within 30 days, or I will file a complaint with the IRS, the SEC, explaining the fraud and theft committed upon me, and issue a 1099 OID. I demand my name and my Sesta K Trust name, Derek Gonzalez, Derek S. Gonzalez, Derek Chaton Gonzalez, Derek Gonzalez, Derek S. Gonzalez, and Derek Chaton Gonzalez be removed from any and all government databases indicating bad credit, commercial liens, and or the titles of criminal, felon, and or convicted felon be removed immediately and permanently non-proton. I hereby request a copy of the depository resolution agreement from the clerk of the court and a W-9 from the judge and the U.S. attorney involved, if you wish to proceed with this case. I hereby notice the court that I am the executor of the Sesta K Trust of Derek Gonzalez, Derek Chaton Gonzalez, according to Title 26, subsection 303 and subsection 7701. Companies, corporations, and associations and trusts are all decedents. This means my all capital letter name is a legal estate. My all capital letter name falls into this class. I direct all of the affairs and financial affairs of Derek Gonzalez, Derek S. Gonzalez, Derek Shaitan Gonzalez. I demand this case account be closed and no further steps be taken to securitize it. I hereby ask the court to notify local agents and agency to put me on a do not disturb list so we don't have to go through this again. I am confident the court and its officers want to follow the law, and perhaps we're unaware of the process of civil and criminal cases. I expect no further harassment from rogue, unregistered foreign agents. Letter rogatory for relief. And then it just has my information there. This is what we did in court yesterday, and it was a lot of fun. It's something similar, but not the same. As you know, similar is not the same. Maximum of law. And while this guy was reading it, boy, oh boy, were they interrupting the crap out of him. You know, nobody else in court was interrupted. The state trooper got to testify. The man that was sitting at the defendant's table, he never interrupted anybody. He was completely cordial and polite, and he knew that we had him by the short and curlies. And boy, when he got up there to testify, I said, this is all you read. You get up there and you sit down, and you don't deviate from it. Let me keep in mind, this guy he beat 2 of the charges, and the third one, and I shit you not, I about come unglued in that courtroom. The judge says, well, there was no intent, obviously, but I'm still going to find you guilty. And I said, wait a minute. I'm in the peanut gallery, you know, and I'm very boisterous. I said, wait a minute a second. You've dropped two of the charges, and you got this last charge because you're trying to save your prosecutor's ass from having to get out his checkbook. That's all this is. And I didn't say this in the court. This is what I'm thinking. So this is what I actually said. Hey, wait a minute. Did you not just state for and on the official record that the defendant didn't obviously have any intent to commit a crime? So there's no malium in se, malium prohibitum. There's no corpus delicti. Like, there's no elements of a crime here at all. And because you can't convict him of his mind, and you yourself don't have conviction in your heart that this man's guilty, but you're still going to find him guilty. But so let me read to you what he read, and you can imagine how many times they interrupted him, because this was amazing yesterday in court, and we had a lot of fun. It says the following: November 1st, 2019, the following respondents: Jeffrey Wichtman, he's a county judge; Deborah D. Hansen, the circuit court clerk, Broken Bow, Nebraska; Circuit 8th District, Custer County, Nebraska. It was a case pertaining to CR, which is criminal. CR is criminal, right? But absent a victim, it's not criminal. So what do we know about it? Oh, it's civil, which means it's a trust. So it's CR 19-174. Notice to agents, notice to principal. Dear Jeffrey Wigham and other respondents, please note, I have been informed that the court sold and or securitized securities bearing, sold bonds and or securities bearing the name, we'll just call him DAS, under SSN number and without my knowledge and consent, which I believe is securities fraud, as well as breach of the fiduciary duties. While I am not making such an accusation at this time, I am giving you an opportunity to rectify the situation. Enclosed you will find the GSA forms OF90, release of lien on real property, and OF91, release of personal property from escrow, SF28, affidavit of individual surety, SF24, bid bond, SF25, performance bond, SF25A, payment bond. These bonds authorize you to order the release of the defendant surety from prison and or condition of release. I demand to be released immediately. I also demand that the record for case number be amended to reflect the proper accounting to maintain the integrity of the data used in the national matching program. It is my intent, through use of these government forms, to provide the remedy to settle and close the case and all associated accounts. It is my understanding that the defendant trust has been an agency vessel of the United States since December 16, 1952, and a resident of the state of Nebraska. Title 26, USC 2031, see also Title 26, 2652, definitions of a trust. Any arrangement that has the effect of a trust is a trust, whether it is called a trust or not. Insinuation, Black's 8th and 5th. Anytime a deed is recorded by insinuation, it's called a donation. Due to the fraud of the secrecy, 2016 balance sheet, a 1041 instruction booklet, page 2, comma 6 and 13, 6209 decoding manual, title 2012, section 1813 L1. Any noted deposited in a demand deposit account becomes the equivalent of cash and is a cash proceed. RCW 62A.3-104E, UCC 3-104E. Any note is a liability instrument, or it can be treated as a draft, enclosed on the back, endorsed on the back as payee, and DAS was the payer as in a check. I am contracting officer for said trust, and no contracts are entered into without my signature. The trust, known as DAS, account number, which is a social security number, has a bonded escrow account located at the DTC from where all necessary funds may be accessed. Title 26 USC 2611 defines a skip person as a trust, including all incidents stemming from, relating to, or having any relationship to, from, or with Custer County, Nebraska, for and on behalf of beneficiary DAS. This fraud was brought upon the court when, as co-fiduciary trustees, they presented the plaintiff principals to be the above listed plaintiffs' principals, knowing that the Securities and Exchange Commission, SEC, SQ/SA, and 424B5 prospectus filings listed different entities' ownership, and I believe that no evidence to the contrary exists. The above named administers, executors, representatives, and fiduciary trustees, while acting in their official capacity, agree to hold the grantor beneficiary DAS man harmless from any liability or loss by indemnification and a bond from any and all possible tax terminations, transfers, distributions, direct, skipped, or originating from the legal estate of the decedent DAS. Political commercial account number, Social Security again, at the expiration of 72 hours of the date of this indenture agreement, indemnity bond without the total and complete correction of the record will constitute a breach of contract with a summary judgment and an international commercial notice of lien on the real and movable property, malpractice bonds, and non-performance bonds of each and every co-fiduciary trustee and co-administrator and all others similarly situated, et al., to be offered to the international community for execution. This appointment will not be affected by the addition of additional co-administrators and fiduciary trustees. From time to time, by the grantor beneficiary man. We see that in Betty versus Gringerham Exploration Co. 122 NE 378 9 of 9, and 225 New York 380 119 NE 575.223 New York 294 9 of 8. Landmark cases, all constructive trusts. As they become known, failure to correct the record and settle the account within 72 hours will constitute a trust ex maleficio and will result in claim of fiduciary trust fraud for wrongful conversion of beneficiary DAS beneficial interest, including the conversion and counterfeited securities and obstruction of justice, with a claim of criminal tax division of the Internal Revenue Service for the criminal tax evasion of $500,000, including but not limited to many years in prison. Trezevant versus City of Tampa, and 1099 OID and 1099C, showing you as the recipient of the funds on this taxable instruments and the international community for the execution of penalties for counterfeit securities issued against the DAS and without any agreement. Purchase to this private settlement agreement judgment. It is declared. There now exists a private contract between us and what I expect of you, co-administrators and co-fiduciary trustees, to remain on your side of the Declaration of Rights that precedes and attaches to the State of Nebraska Corporation Constitution, and what you remain in the State Corporation Constitution and out of my domain, which is the Declaration of the Bill of Rights, and it is the intent herein that any conduct, court proceeding, are intended to be of competent jurisdiction, and it is the intent herein that the plaintiffs are corporations, and it is the intent herein that the plaintiffs have failed to state a claim upon which relief can be granted, 12b-6, and it is the intent herein that the act of criminal bartery will be charged to the clerk of the court and or the court administrator for any reassignment of fiduciary duty by the court administrator and or the denial to their filing of the private settlement agreement, order creating the denial of the rights to access the court. And it is the intent herein that the act of criminal bartery will be charged to the judge, agent, clerk of the court, and or court administrator for any controversy brought into this court in opposition to the private settlement agreement and counterfeit securities pursuant to Title 18 U.S.C. subsection 4 of the Commission of Crimes cognizable by a court of the United States under Title 18 U.S.C. subsection 513, to wit, 513A, whoever makes, utters, or possesses a counterfeited security of the state or political subdivision thereof, or of an organization with the intent to deceive another person, organization, or government shall be fined not more than $250,000 or imprisoned not more than 10 years or both. See also section 2311, 2314, and 2320 for additional fines and sanctions. Among the securities defined at Title 18 U.S.C. subsection 2311 is included evidence of indebtedness, which, in a broad sense, may mean anything that is due and owing, which would include a duty, obligation, or a right of action. It is the intent herein that abuse of office and official misconduct will occur for any failure of the clerk of court and or court administrator and or judge agent to place this private settlement agreement into the evidence file, and it is the intent herein that standard judicial operating procedures, SOP, can never overrule obstruction of justice or due process, Trezevant versus City of Tampa, and it is the intent herein that any applicable damages shall be addressed at the rate previously set in Trezevant versus City of Tampa Bay, and it is the intent herein that administrator, executors, fiduciary trustees provide equal protection of the law as a matter of law and as a matter of record, and it is the intent herein that administrators, executors, fiduciary trustees comply with federal congressional legislation by not upholding recoupment, and it is the intent herein that the act of criminal bartery, abuse of office, and or official misconduct will be charged to the judge, agent, clerk of the court, and or court administrator for any failure to acknowledge and deliver this private settlement agreement judged pursuant to the tenets herein, and it is the intent herein that the judgments is acknowledged by the plaintiffs and the clerk of the court, and it is the intent herein that the judgment is entered with prejudice. I have a right to redeem the bonds which the court sold in the defendant's name and social security number. Therefore, I am replacing those bonds with the enclosed bonds. I now own this case. The enclosed form authorizes you and indeed orders you to, and that's where the judge freaked out. He says, "You're ordering me?" And he just turned at him and smiled and said, "Yep." And he goes right back to reading. ordering you to recall all the bonds, securities which were previously sold in my name and social security number, and refund these monies to me, as those funds belong to me. Obtain your funding through the bonds enclosed. Send a statement of account showing a zero balance and a clerk for all bonds monies previously received on this account to the above mailing location. Release the defendant surety from confinement and all conditions of supervised release immediately. These forms are not subject to the direct discretion of the court or other recipients. If you think you have reason to reject these forms, you are required to provide proof of claim via a sworn affidavit as to why you are not required to accept the forms, or advise me of any defect you may find in the forms, and provide your bond in support of your position. Your failure to do so will be certified as fraud on your part pursuant to U.S. versus Tweel. Please note that the court's comments are directed to Internal Revenue Service employees and apply equally to all government employees. Silence can only be equated with fraud when there is a legal and moral duty to speak, or when an inquiry left unanswered would be intentionally misleading. We cannot condone this shocking conduct. If this is the case, we hope our message is clear. This sort of deception will not be tolerated, and if this is routine, it should be corrected immediately. U.S. versus Tweel, 550 F2D 297, 299 through 300. Your responsibility. I understand it may take you 30 days to process the enclosed bonds, but I require a good faith letter from you within 15 days of the postmark of this communication acknowledging receipt of the bonds and your good faith intentions to process the bonds and release me. Or in the alternative, your affidavit and bond in support of your claim of a defect in the bonds. I am also requesting copies of the 1099 OIDs, which were or should have been originally filed in regards to this case, as well as copies of the IRS 706 and 709, which should have been filed. Your failure to respond within this time frame in the manner stipulated will compromise your default. Failure to respond pursuant to the said terms of response, or specifically perform under the provisions of the enclosed government forms, i.e. credit and ledger claimant tender of consideration, will compromise a default on your part. As an operation of law, a default will compromise your agreement, consent, and confession to all the terms, statements, and facts herein and herewith, and all inclusions and endorsements front and back annexed hereto. Your default will compromise your confession to holding all liability in the aforesaid matter. Your stipulation that the above noted party has exhausted his or her administrative remedies, and your consent to all necessary collective procedures. As well, your default will compromise your confession to securities fraud, tax fraud, breach of fiduciary duty, and false imprisonment, and will be certified and reported to the Nebraska governor and the comptroller of the state of Nebraska, the Attorney General, the IRS, the Office of the Inspector General, the GSA General Service Administration, and the Securities Exchange Commission, the SEC. Your default will compromise your agreement to the arrest of your bond and to the filing of criminal complaints and or torts against you. Confession of judgment. Default will compromise your agreement to accept and pay certain fees. Your default is your agreement to pay a co-claimant fee of $50 million for the privilege of being joined as a co-claimant against legal fiction DAS, pursuant to each attempt to impair the claim or stultify the claimant, me, or the debtor, the trust, self-executing power of attorney. To facilitate your strict compliance with all the terms of the contract, if you fail to correct the default within 10 days, you give, by remaining silent, unlimited power of attorney to claimant to sign and execute for you regarding enforcement of your obligations under this contract. In that event, you instruct and authorize the claimant to execute respondent's signature in representative capacity on self-executing power of attorney documents. Estoppel by acquiescence. Your default will compromise your agreement that all issues pertaining to the contract are deemed settled and closed, res judicata, stars dices, and collateral estoppel. And as a result, judgment by estoppel, and therein you will be confessing to the criminal act of the false imprisonment should you fail to release me. Waiver of rights, confession of judgment. Your default will compromise your consent, your agreement and confession to waiver any and all rights, to raise a controversy, appeal, object to, and convert administratively or judicially any of the terms and provisions in this contract or the estoppel, as well as your consent to serving as a successor surety for the obligations, for all obligations, commercial and corporal, attributed to the account. Upon default, you and your agents may not argue, convert, or protest the finality of the administrative findings to which you have agreed unless such waiver of rights which follows is declined in writing. Any such agreement of controversy will compromise your confession to perjury, enticement to slavery, and various crimes against humanity. The respondent's confession of judgment in the said amount is res judicata and stare decisis. Denial of waiver of rights. I, the respondent, hereby acknowledge that I have received, read, and fully understand this administrative remedy presentment with attachments, endorsements, and schedules, and do hereby reserve the rights to raise a justicable controversy by exhibiting verified proof of claim and loss, no later than must be within 10 days, and of date of signing below, unless written permission for a longer period of time is obtained in writing from the third party intervener, real party in interest, under injury. In the event the said claim is honored, I further agree to settle all associated accounts to the zero balance, final ending balance. Respondent's autograph and date. Certification and recording of non-performance for evidentiary purposes. For your protection, non-performance will be certified and recorded in the public record as evidence that DAS has exhausted his administrative remedies and that you have elected to waive all rights and raise a controversy or claim immunity from collection proceedings, having declined the opportunity to plead. Thank you for your assistance with this matter. Sincerely, DAS. Government created Ens Legis Trust by DAS, authorized representative, beneficiary, entitlement holder, and he's of course got a Georgia UCC1 filed. And so you have that filing number in there. You can about imagine how skippy that judge was after this man got done reading this. And he had the gall to say, well, I don't understand that, and none of that makes sense to me. Well, I'm happy to hear you say that, partner, because it leads me to believe you're not going to do your job. And we'll take care of that issue on the backside. Because if you stick to your paperwork, guys, and you follow up with the Inspector General of the AIG, or excuse me, not the AIG, the Attorney's Office, the SEC, the DTC, you start contacting these people. You start giving them what you gave the court. This was given to a very specific group of people, and they have a fiduciary duty because we gave them the 56F. We appointed them as trustees over this matter, and they looked at it and they go, oh, well, we don't know what we're supposed to do with this, and they just threw it off to the side, and I was like, okay, good luck. So anyway, stick to your guns. You'll get your results. For those of you that are struggling out there, I hope these videos are really helping you out. Thanks for joining me this morning. I'll try and do some more videos. Trapper Kills Many has sent me some documents a while back, and I'm telling you what, these things are fire. Absolutely unbelievable. And I'll get into them. Because they're too good not to. So let me just give you a small sample of one here. This is authorities. It goes through Genesis. It goes through Exodus, Psalms, Ezekiel. And remember, I keep telling you guys, the Bible is very, very, very important. Even though the King James Bible may be perverted, it still has the truth in it if you know how to look at it. So I will do my best to present this to you, because it's amazing. And Trapper Kills Many, that guy he's an ace. He's an ace in the hole. His paperwork is like I've never seen before. Notice of declaration of cancellation and revocation under and out of the authority of absolute necessity. Notice to agent is notice to principal. Notice to principal is notice to agents. By these presents, under full liability and complete transparency, sui juris, under the laws of the Creator and the laws of the creation. Out of and under the authority of absolute necessity, being of plenary capacity, character, condition, standing, status, and responsibility. I, Derek Tom Gonzalez, do notice, declare, affirm, proclaim, and publish the following to wit: that for fraud, non-disclosure of pertinent facts, lack of authority of the other signatory party, no meeting of the minds, duress, coercion, threats, lack of consideration, and failure to provide the following to wit: personal identification, employee ID number, valid bond and insurance, valid oath, accommodation agreement authorizing them to present and represent the former United States of America and or state of Nebraska, production of the statute, implementing regulations, state and federal register volume and page number stating I must comply without my consent and authorization, authorizes jurisdiction over a real man, living soul, identifying their principle of law. I do hereby declare, notice, proclaim, and publish that any and all documents, papers, agreements, contracts, tangible mediums, and or tangible items, or any nature, shape, cause, kind, form, and format, and any and all variations and combinations thereby, thereof, by, and between Derek Tom Gonzalez and the former United States of America and the state of Nebraska are for the aforementioned cause canceled, extinguished, voided, and discharged without dishonor, without limitations, ab initio, non pro tunc, in perpetuity, creation dash wide, without recourse, without prejudice. Further, I, Derek Tom Gonzalez, for the aforementioned cause, do hereby rescind, revoke, cancel, void, and annul my signature and or autographs for any and all documents, papers, agreements, contracts, tangible mediums, and or tangible items, or any nature, shape, cause, kind, form, and format, and any and all variations and combinations thereof, by and or between Derek Tom Gonzalez and former United States of America and the and or state of Nebraska, without dishonor, without limitations, ab initio, non pro tunc, in perpetuity, without recourse, without prejudice, creation wide. In all the instances of the use of the letter combination former the United States of America, it shall mean the following to wit: United States of America, aka doing business as the United States of America, aka doing business as the United States, aka doing business as the United States, aka doing business as the unknown. Foreign entity trustee, and any and all derivatives, appellations, identifiers, numbers, and their combinations, letters and their combinations, abbreviations, idioms, synonyms, and or all other legal, financial, and managerial forms and formats of any nature, shape, cause, and kind, and any and all variations and combinations thereof, and any and all corporate, military, commercial, civil, political, social, ecclesiastical, and other entities of any nature, shape, cause, kind, form, and format, and any and all variations and combinations thereof, and any and all creations and liabilities by, of, through, and from of any nature, shape, cause, kind. I mean, the guy is just brilliant. He wrote this up like a lawyer. I hate to say that because they talk in circles a lot. They give you 50 freaking pages that all say the same stuff, and they throw one little sentence in there because they know you're not going to read all 50 pages. One little sentence that gets you. That's how you get nabbed up in your contracts. Nobody reads them. They go through this rhetorical stuff, and then they miss the big hook, line, and sinker. So anyway, that's from Trapper Kills Many, and that man was on point. And I have a number of just some brilliantly executed and designed documents that just leave no wiggle room at all. And then I also have some of my stuff that I did in my last court case, the letterogatory, the affidavit of life, the affidavit of forgiveness, a forgiveness letter. Remember, if you can't forgive them, they can't be expected to forgive you. So it's not to say that you're not owing just compensation. I'm just saying you have to be able to forgive them in your heart because they know not what they do. So thanks for joining me this morning. I hope you guys learned a little bit. Share this with your friends and family. The people are waking up. It's amazing. The people that I interact with on a day-to-day basis it's just overwhelming to see how many people are truly starting to have an ascension of the mind. And so stay positive. Keep your message healthy. Remember, all wars are won with a pen. Nagasaki and Hiroshima did not drop until somebody used a pen. All right? That's very, very, very important for you guys to understand that. The United States was never free from Britain. We won the physical war because they couldn't physically be over here. They were fighting too many other battles and they couldn't be here. You know how they beat us? With a damn pen, ladies and gentlemen. So get learning, get the knowledge, and start standing by your fellow man. Help them out in court. Go to court, be a court watcher. Even if you don't know what's going on, dress sharp, look fly, go in there like you know what you're doing, and just take a pen and a piece of paper. It intimidates the shit out of those black-robed judges or alleged judges that are fleecing the American people. It scares the shit out of them because they don't know anymore who's learned and who's not, and it makes them nervous. So with that said, have a great day. Be blessed. Thank you very much for your time. Enjoy your weekend. Be safe out there. And always make sure to tell your loved ones hi and goodbye because you never know when the last time you're going to see them.